2022 CR 10756, State of Texas versus Marcelino Scott. Bad parties announced for the state.
Ruben Herrera and Brittany Mitchell for the state.
For the defense.
Jessica Gonzalez
and Tracy Franklin
for Mr. Scott.
All right. And my understanding, the defense has filed a motion.
Yes, Your Honor, I filed two motions. The first one I'd like to address with the court is going to be my motion to dismiss for lack of due diligence and violation of constitutional rights.
All right. You may begin.
Thank you, Your Honor. The first thing I'd like or ask the court to do is go ahead and take judicial notice of the date that I went ahead and cited in my motion. My client was arrested, according to the public record system, my client was arrested on June 28, 2022 for a crime that allegedly occurred on June 27th and then June 20th of 2022. There are several dates that I've cited in here of when he's demanded his right to speedy trial on January 9th, 2023. At one of his trial settings, he was ordered to be dressed and ready for trial on February 7th, 2023 trial setting. There was another trial setting I put on here February 1st, but I'm sorry, that should be February 14th for what he was scheduled for. And then his trial setting was reset to this current trial setting.
Counsel, just so the record can be noted, the trial date for, I believe it's January 13th, the court was in jury trial.
Okay, thank you, Your Honor. My client will be, we talked to him this morning, he will be prepared to testify to some of this information and the time that he came back for court. The defendant appeared in court on April 11th for this current trial setting with trial counsel, and we all announced ready for trial. The court ordered all parties to return on April 12th in order to select a jury. Before jury selection, we all signed a discovery acknowledgement and we presented that to the court, and I believe the court signed it on that day. And then from there, we did do jury selection where we selected a jury of 12 people and one alternate that was seated at 2 p.m. At that time, the court excused all parties for the day. We recessed for the day because of a personal emergency with the defense counsel. However, we did all leave the courtroom early enough in the afternoon. What happened from there is, and this is the crux of my motion, is at 9:54 last night, I received an email which I attached as an exhibit, and I also have a clean copy that I can also tender to the court and introduce into evidence if the one that's on the motion is not sufficient. However, I received this email at 9:54 last night from the lead prosecutor, Mr. Herrera. This email also contained about, I think it was a total of 5 pages, but when you put everything together, I think it comes out to about 4.5 pages of typed notations, notes that he took in speaking to the complaining witness in this case, and one of the other witnesses that he did express to me that he does plan to call as a witness to one of the offenses. So this email was sent to me after the jury was selected, which is a very big point for my motion, but also less than 24 hours when testimony was set to begin. Now, with that being said, in doing this, the district attorney's office has thrown my client into what I coined at 2 a.m. this morning as I'm going through all of this information as the Bermuda Triangle of where his constitutional rights are being violated. In this motion, I identified 3 specific constitutional rights that are being implicated with what the prosecutor did with that email and that late party disclosure notice. He has violated my client's constitutional right in order to prepare for trial by giving us this information. He's given this information after we have already selected a jury, after my client has already made the decision to reject any plea offers. Therefore, his decision to proceed to trial is no longer intelligently and knowingly made. He's also violated my client's constitutional right to confront the witnesses. As we go through this motion and we start looking at the possible remedies that are available to the court, one of the remedies is to be able to exclude the information that was provided in this notice. However, by doing that, he is now preventing us from effectively cross-examining a witness. So therefore, the prosecutor violated my client's constitutional right to fully confront the witnesses. And then lastly, he has violated my client's constitutional right to a speedy trial. I do know that we're now within 1 year of the offense date. However, my client demanded a speedy trial, and that's what he was getting. This court was providing to my client that speedy trial he asked for. Yet, by doing this, we're now having to look at another delay in this case because of this tardy disclosure. Everything that we're looking at right now, and I'm asking the court to consider, is because of the state's failure to get this information to me and to my client anytime before less than 24 hours before we're start to set testimony. The Texas Code of Criminal Procedure imposes a duty on the prosecutors to turn over discovery in their possession of the state as soon as practical. Now, in the email that I did provide to the court from Mr. Herrera, he did state in there that he had just spoken to these witnesses that afternoon. And I completely understand that. However, under State versus Heath, that court in Waco, the Court of Appeals, has gone ahead and extended that as soon as practical date to putting an additional duty on the prosecutors to go out and affirmatively get this information, not just as soon as practical, and not just when they're ready to prepare for trial, but getting it to the defendant in order to preserve his constitutional rights to prepare. Now, in doing this, as I stated, we're now left in a situation that the only proper remedy for my client and to cure all of these infringements is going to be for a dismissal. As I explained, if you exclude the evidence, you're violating his right to the state has violated my client's constitutional right to confront the witnesses. If you give us a continuance, then we're now violating his constitutional right to a speedy trial. Furthermore, my client has not had sufficient time in order to go through this document that was provided to us at 9:54 last night. With that being said, Your Honor, I'd like to call my client as a witness to lay further information for the court to consider.
All right, you can call your client.
Mr. Scott, and Your Honor, just for the record, this is just for the limited purposes of this hearing.
All right, Mr. Scott, if you'll take a seat. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Marcelino Scott.
All right, defense.
Mr. Scott, have you requested a trial in this offense?
Yes.
And did you do that because you're wanting a trial to be able to share your side of the story of what happened?
Yes.
Are you currently employed?
Yes.
Where are you currently employed? Okay. And are you having to take time off of work in order to come here for these court appearances?
Yes.
Do you remember how many times you've come in for trial?
The reset dates or the amount of days?
All of the dates, sir, that you remember.
I think it's been 4 times that I've come in for extended period of time.
Okay. And when you say an extended period of time, what do you mean by that?
I would, for example, it came in for trial January 6th, maybe, and it was a Monday, but it kept getting reset because of different trial dockets. So I had to keep coming back every day that week.
Okay, so when you say reset, do you actually mean recalled, like you were told to come back the next day?
Correct.
Okay. And each one of those times, did you have to take off of work?
Yes.
Has doing that the multiple times put your job in jeopardy? Even though you have the job right now, is it causing tension at work?
Yes.
When was the first time you saw the document with the additional statements of the complaining witness?
This afternoon when I came in,
Okay.
approximately about 1 o'clock.
Okay. Have you had sufficient time to go through that document line by line with me?
No.
Is there information that you've reviewed in that document that you would like to get evidence for to oppose it?
Yes.
Okay. Will that take additional time to be able to get?
Yes.
Did you already take off in order to be here for the trial that we're doing right now, going forward, to go continue with testimony?
Yes.
And I'll pass the witness.
State.
Mr. Scott, have you been told by your employer that your job is in jeopardy?
Yes,
How's that?
because I started on October 20th and you can't miss any work for the first 12 weeks. And then since the time in January, I've missed time a lot because of coming to court, and they were asking me why am I missing so much time.
But have they told you that you're
Yes, because
imminent to be fired?
yes, attendance adherence would cause you to get corrective actions that could lead up to termination. And I already was under the probationary still.
But have you been specifically told that you will be fired?
Yes,
And what time approximately was the first time you saw the document that the state tendered to your defense counsel?
it was 1:30, like today I came in.
Okay. And Mr. Scott, you were booked for these charges on June 28th of 2022. Is that correct?
I'm assuming correct, because I was arrested on June 27th.
And when you were hired in October for your current job, did you let your employers know that you would be having court proceedings at the time that you were hired?
No.
Okay.
I did not know about it. Relax.
And Mr. Scott, at this point, have you read the disclosures that the state provided to your defense counsel?
Briefly, yes.
But we haven't read the whole document.
No.
And Mr. Scott, when were you told that these disclosures were made to your attorneys?
When I ordered in my press conference room at about 1:30-ish.
Were you notified by your attorneys prior to that the state had made these disclosures? Had they attempted to contact you at any time this morning to discuss those disclosures?
Not that I know of.
Were you aware that your attorneys were going to be filing this motion to dismiss this afternoon?
No.
Nothing further, Your Honor.
All right, anything else?
No further questions of this witness, just continued argument.
All right, you may step down. All right. Court will hear brief argument.
Yes, Your Honor, the thing that I would like to end with is specifically talking about this defendant's time to prepare, the constitutional right. The Sixth Amendment to the Constitution specifically says the assistance of an attorney. The case opinions that came out after that have coined it as the time to prepare. I think what the prosecutors were just trying to get at is just simply by Mr. Scott or them having notified us of these statements and that this was done, that fulfills their obligation and that now satisfies the defendant's time to prepare. And that's just simply untrue. Your Honor, when we're looking at time to prepare, we're not just talking about looking at a statement and reading the information and absorbing it. You're talking about tracking down the additional witnesses that are listed in these statements. You're talking about investigating that background. You're talking about subpoenaing people, looking for witnesses that are going to go against and contrary to what that new information is. Time to prepare is exactly what a person is guaranteed by the Constitution and what we're looking at. The state of Texas has violated the client's right and the time to prepare, along with the speedy trial and along with the his right to confront the witnesses. Any other cure other than a dismissal is going to infringe one of the other rights. That's why I coined it the Bermuda Triangle. That is why I am asking for a motion to dismiss. That is the only way for us to be able to fix the situation that the state of Texas has put my client and myself in by providing this disclosure. Under Heath, again, they have the duty to do this sooner. They can't just rely on the fact of they decided to prepare for the trial at the day after jury selection. It's after jury selection that they spoke to this witness. They've had the past 9 months, 10 months to be able to speak to the witness to get that information, but they chose after jury selection. That means they're assuming the risk that if those witnesses give them additional information that they have to tender, they are now taking on the responsibility of possibly having a case dismissed because of their fault of not doing this in a timely manner. That is why I'm asking for the court to grant this motion to dismiss. Thank you.
State.
Your Honor, for the state's first argument, Your Honor, as counsel has noted in their motion to dismiss, we did tender these disclosures to counsel at 9:54 p.m. As this court is aware, we were in court selecting the jury for this case, anticipating a proceeding at one point. And as is noted in the motion, the parties were in the courtroom until approximately 2:00 p.m. It was at that time that we went to our offices to prepare for trial with the complaining witness and her daughter, who's another witness that the state's anticipating in calling to testify. That meeting, Your Honor, went on until approximately 5:00 p.m. And those notes, as is customary of our office, are taken by our victim's advocate in shorthand, as there's a lot of information that is presented. And so in addition to having that meeting, it was my responsibility to annotate those so they would be legible to counsel. Those were tendered again at 9:54 p.m., which was the earliest that the state had the ability to provide those to counsel. As the defendant testified on the stand, he was unaware until 1:30 p.m. when the state and defense were to be in the courtroom prepared for trial of these disclosures. And I understand counsel's position where they may have other cases to prepare for on the day, but the state has the same burden, Your Honor. Counsel could have met with the defendant at any point up until 1:30 to discuss the disclosures and discuss any of the information that was presented in order to determine if any evidence would need to be obtained in order to defend themselves against any allegations or disclosures that were made against
All right,
the
here's
defendant.
my question.
Yes, Your Honor.
I've read through defense counsel's motion. The recitations, I guess that's by Ashley, I'm sorry, the additional statements. Are any of these additional statements that are listed in your notice to the defense, are those in other places in police reports or in other statements?
A majority are, Your Honor, listed in police reports for these incidents that are alleged in the indictment, as well as reports that were tendered to counsel regarding previous incidents involving the defendant and the complaining witness. There is other information that the state was unaware of up until yesterday, and that was not listed in prior reports as well, Your Honor.
Our part of defense's motion, I'm sorry, of notice to the defense was not in prior police reports or prior statements. And let's start on the page beginning with notice of additional statements.
Your Honor, defense counsel was provided with documents regarding the protective order. So that information should have been included in subsection A or subsection 1.
Is there anything on that page that was not previously tendered to the defense in the form of a police report or a statement from anyone?
Your Honor, in regards to all of the disclosures that were tendered, there is a mix of statements that were made as well as additional information that was given to us by the complaining witness surrounding the allegations.
Oh, but what I want to know is there anything on that page that was not previously tendered to the defense in the form of a statement that they've had access to or something that's in the police report? So this is what I want from each party.
Yes, sir.
I want you all to confer right now, and I want somebody to highlight that portion of the additional notice of additional statements. I want that highlighted on what the defense did not know about.
And Your Honor, if I may, that's kind of what goes to the crux of part of my argument of.
Here's the thing, I want you guys to do that, then I'll hear the other argument, but I want that done now.
Well, what I'm saying is there's multiple statements, multiple statements.
Yeah.
Okay.
All right, so we're back on the record in 2022 CR 10756. All right, with regards to defense's motion to dismiss, that will be denied. With regards to what's tabled, notice of additional statements that are being submitted to the defense. If these are not statements that are in a police report, if these are not statements that have been tendered to defense counsel before, then it will be excluded. With regards to the witness who's mentioned in here, and I believe that's the daughter. If that information with regards to the daughter, if that's not in a police report, if that has not been tendered before, then that will be excluded. Is there anything else with regards to the motion?
I think your orders are clear. However, there's a few, I think defense and I might disagree on what suffices as mentions. Because there are indications in like the 2089, she talks about, she just wrote choking Beaumont with a date. But obviously she didn't go into detail about the Beaumont, which she did with us yesterday. So I think we might have a disagreement as to what qualifies as something that they had notice of. Like with regards to that, I guess.
All right, you all can make your objections when the witness testifies. Before you go into that state, you'll need to approach.
Yes, Your Honor.
With regards to, I believe it's the daughter that's mentioned in one of these statements. Again, if that is something that is not in a police report that has been given to the defense, or some statement that has previously been given to the defense, it will be excluded. All right, anything else with regards to the motion to dismiss?
Not for the motion to dismiss. I have the motion for continuance on file also, Your Honor.
All right, the court will hear your motion for continuance.
Yes, Your Honor. I filed the motion for continuance in anticipation that if the court were to deny my motion to dismiss for the constitutional violations, the next step would be for me to ask for a continuance in order for my client to prepare. As he previously stated in the other hearing that we did, we have not had sufficient time to go through this line by line with him and for him to be able to give us the information to contradict. Now, while the court may be excluding some of the information that may be excluded may actually be considered Brady information because of the fact it's contrary to what they previously provided in their statements to police officers, in their statements to CPS, and in their statements in the protective order hearing. As the court is well aware, giving contradictory statements multiple times, that is a defense, and that is a valid defense available to my client when he's looking at these types of charges. At this time, with this information being given at this late notice, we have not had the opportunity to go through everything for him to be able to provide me his side of the story of what they've been given, or what the state has given to me. And as the court is well aware, this is why this court has multiple settings in order to make sure that discovery has been complied with. That is why we have to sign the discovery acknowledgement. It is very akin to what the court was afraid of yesterday with the fact of the first chair, the attorney of record, possibly having to step out of the case. We're looking at a situation that's going to come back on appeal because my client has not fully prepared given this new information with this tardy disclosure. So I'd ask for the court to grant my motion for continuance, and so we can continue preparing for this trial.
All right, so Ms. Gonzalez, are you the attorney of record on this case?
I am not the attorney of record. Ms. Franklin is the attorney of record. However, I'm sitting as co-counsel for her, with her.
And have you signed on and filed a notice of co-counsel?
I can, Your Honor. I have not done that yet.
You have not. And so the court doesn't have technically and legally the motion for continuance technically and legally, the motion for continuance, the motion to dismiss for lack of due diligence in violation of constitutional rights should not be something the court should have heard because you're not the attorney of record. But the court is hearing that. Just one moment, please. All right, motion for continuance is denied. Is there anything else from either side?
Nothing from the state, Your Honor.
Yes, Your Honor. In that case, I would ask orally for a motion for mistrial.
All right, that's denied. And the court will note for the record that defense counsel is not the counsel of record. All right, let's bring New Jersey.
Your Honor, one clarification. We actually did clarify that issue yesterday on the record orally when we handled the issue of Ms. Franklin having to possibly step out yesterday. We put all this information with me being appearing on the record for Mr. Scott in this case on the record yesterday.
All right, my understanding is that who would be appearing on the record would be if Ms. Franklin could not continue, it would be Mr. Archer. Was his last name Archer?
Mr. Archer would be sitting with me, but I was going to be taking lead on the case.
All right, let's bring New Jersey if they're ready. I'm calling 2022 CR 10756, State of Texas versus Marcelino Scott. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Jessica Gonzalez from Mr. Scott.
Are you
Franklin
Scott?
from Scott.
Oh, no problem. I'm sorry about that. Reannounce.
Tracy Franklin for Mr. Scott.
Are you Mr. Scott?
Yes, I am.
All right, everyone can remain seated. Defense, have you received all the discovery? Did you review it with your client?
Yes, Your Honor. However, we signed the discovery acknowledgement yesterday. Sorry. We do have the one addition, which would be the Brady memo that was emailed to me last night.
The court then will find that the state is in compliance with discovery. Mr. Scott, have you reviewed the document entitled Application for Deferred Adjudication of Community Supervision with your attorneys? Did you understand it and did you sign it?
Yes.
And have you reviewed the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding as to count 2, the lesser included charge of assault, bodily injury, married cohabitation.
Any objection?
No objections.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I think the better way for me to answer the court's earlier questions with regards to the affirmative finding of family violence is that in our plea agreement is that it was my understanding in talking to the prosecutors about the case is that we would be going open on that affirmative finding. I would present my arguments to the court, but we also did, by we, I mean my client and I, Mr. Scott, did understand that the court will be making the affirmative finding of family violence.
All right, I'll hear your argument.
Thank you, Your Honor. With regard to the affirmative finding of family violence, I would ask all to be able to look at Article 42.013 of the Texas Code of Criminal Procedure. This is speaking directly to the finding of family violence. It does state at the end of the paragraph that the court shall make the affirmative finding of fact and enter the affirmative finding of fact in the judgment of the case. The next argument in support of asking the court not to make this finding is going to be under Article 42.01, which is specifically describing in the Texas Code of Criminal Procedure the meaning of the word judgment. Section 1 states a judgment is the written declaration of the court signed by the trial judge and entered of record showing the conviction or acquittal of the defendant. With those two words, Your Honor, put in those two articles put together, we are saying that with my client's case being deferred and he's going to be placed on deferred adjudication, that being placed on deferred adjudication and looking at all of the orders that come from the court, it is actually an order of deferred adjudication, meaning that he will not be found guilty, which is required for a conviction at this time. Now, of course, if he comes back from the court before the court on a motion to revoke, and the court does revoke his community supervision and does make a finding that he is guilty of this offense, that would be a conviction. And at that time, an affirmative finding of family violence would be appropriate. But while he is on deferred adjudication, and if he completes it successfully, that an affirmative finding of family violence would not be appropriate as defined by by Chapter 42 of the Texas Code of Criminal Procedure.
All right, state.
Your Honor, it's the state's position that because there was a family relationship between the defendant as well as the complaining witness, and that they had a previous dating relationship. And while they were no longer dating at the time of the incidences, or at the time of the incident, they were cohabitating in the same household, that satisfies the statute in indicating that there was a family or household relationship or a married cohabitate relationship, and that the affirmative finding be enforced.
All right.
And Your Honor, just to respond to the state, we have no objection to that statement and that there is that relationship. We are strictly talking about the judgment and conviction language of the Texas Code of Criminal Procedure.
All right. This is what the court will do. The court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with the BIPP course, regular reporting by Zoom or in person, proof of employment within 30 days. There's to be no employment as a home health care provider with minors, regular UAs, 80 hours community service restitution. Those hours will be satisfied once you've completed parenting classes, and that will be with Triple P. Field visits one time per month for 2 months. Probation, if there's no issue with the field visits, then those can be discontinued. Probation, is there anything else that's needed?
No, Your Honor.
Mr. Scott, is there anything else you need from the court to be successful?
No more. No, Your Honor.
All right, Mr. Scott, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, we can go off the record. Mr. Scott, good luck to you.
Thank you.
All right.
But Your Honor, one other thing, and I don't know if it needs to be on the record, but my client did inform me that he does take CBD oil. So we would be asking that the first initial UA be actually get the levels of it. So that way we have as a baseline to show that he's stopped using any substances if it's going down.
All right. So, Ms. Abrams, if you can make sure that they test him for levels.
Defendant Marthelino Scott faced assault family violence charges. After jury selection concluded, the prosecution sent a late-night email, 9:54 p.m., with new witness statements, prompting defense attorney Jessica Gonzalez to file a motion to dismiss, arguing violations of the defendant's rights to trial preparation, witness confrontation, and speedy trial. Scott testified he risked losing his job due to repeated court appearances and had insufficient time to review the new disclosure, seen only hours before trial. The judge had both sides identify which statements were genuinely new. Undisclosed material was excluded from trial, but the motion to dismiss was denied, as were subsequent motions for continuance and mistrial, partly because Gonzalez wasn't the official attorney of record. Trial proceeded, and Scott pleaded to a lesser charge, assault with family violence. The court sentenced him to 2 years deferred adjudication, with a family violence finding, no contact order, community service, parenting classes, and drug testing.